Great. Good afternoon, everyone. Welcome to this week's coronavirus webinar. My name is Kathy Purdy. I am the marketing manager here at Schoeneck King. Just two quick housekeeping items before we get started. Please enter your questions through the Q&A box located at the bottom of your screen, and we will do our best to address those as time allows. Once the webinar has finished, if you would take a moment to complete the brief survey, we would appreciate that. We do share your comments with our presenters, and they look forward to your suggestions for future topics. So to get started, I'm going to hand today's presentation over to Pete Jones.
Thank you, Kathy, and good afternoon, everyone. It's good to be back with you again. We've got another full program for you today, so we're going to kick it off with Katie Anderson. There's a lot going on in Albany, and Katie's got the update, the weekly update with a few extra nuggets this week. Katie, take it away.
That's right. There's always a lot going on. I know that you all hear me say that all the time, but it feels like this week there's even more going on than usual. Let's start with where we're at in terms of COVID. We've seen the cases really, we're looking at a pretty flat decrease. I know that's an oxymoron of a term, but it's a slow decrease in the cases. Today, I mean, just a few minutes ago, the first Brazilian variant was detected in Manhattan. That is concerning. That variant has a lot of things that are different between the other variants. It has reinfected people who've had COVID previously. It has a pretty strong mortality rate. So it's very concerning. But again, its effectiveness, the vaccines appear to be just as effective against it. So that is positive news. And one thing I wanted to illustrate to everybody is where the cases are currently in New York. If you look at this map, you can see that really the cases are concentrated again downstate. You have the lower Hudson Valley, New York City, Long Island. But that doesn't mean that it's not happening elsewhere, right? You're looking at Delaware County. Delaware County has a pretty high amount of cases. Same thing with Buffalo. Erie County also has a pretty high level of spread. So keep your eyes out for that vaccine rollout. And I'm going to talk about eligibility in a second, so don't worry. Looking at the current pace, great news, May 15th, we are on track to have 50% of the adult population be vaccinated. That's excellent news. I, for one, can't wait to get vaccinated. So those, those numbers continue to be better and better every week. So that's just excellent news. New vaccine eligibility. Everybody has been asking this question: when am I going to be eligible for the vaccine? Well, at this point, we at least have a definite date by which you will be eligible if you're not eligible already. The president announced last week that all states must make vaccines available for all adults by May 1. It's likely that New York will open it up before May 1, but at the very latest, May 1st is when all adults will be eligible to receive the vaccine. I'm sure that there will be appointment backlogs. Again, the supply here is really not keeping up to pace with the demand, but that's okay. We have a longer period of time to vaccinate everybody. But we know that by May 1, everyone will be eligible for a vaccine. That's great. But what's currently happening, New York recently, last week, updated the eligibility. We did mention it briefly. We've gotten a little bit more details as to who qualifies for the vaccine under this new eligibility. First, public-facing government and public employees. So you think about a DMV employee. It's a great example. They are eligible for it. Not-for-profit workers who are helping New Yorkers in need in a public-facing way. So like a reading program for children that you want to meet in person. That type of a thing you would qualify to receive the vaccine. And then finally, and this one's big, essential in-person public-facing building service workers. It's a long name, but it's really anybody who's working within a building structure. The press release put out by the governor's office mentions sanitation workers, but it also includes, your HVACs, contractors, people who are in buildings doing things. I know that's a really not a great description, but that is what it's been opened up to. Again, all of these categories have been a little bit mushy is the best legal term for it. It depends on where you're getting your vaccine. Places have allowed people to receive vaccines on more broad bases than other vaccination spots. So really depending on where you are in the state, that will be, that may determine how you get the vaccine. But if you have questions, please contact one of your attorneys to discuss if your employees are eligible for the vaccine. So now we're getting into some more nitty-gritty. New guidance documents. These guidance documents were updated, so we have a few to go through. First thing, March 10th guidance document published last week by New York. It's about quarantining after exposure. This is in response to the February 13th CDC guidance, not the most recent CDC guidance that I discussed last week. Okay, so that's an important thing because of the following. Fully vaccinated people, so you received your vaccine 2 weeks ago, at least, do not need to quarantine if they are exposed to someone with COVID-19, so long as they remain asymptomatic and they received the vaccine within the past 3 months. That last part, receive the vaccine within the past 3 months, is not on the most recent CDC guidance. We do anticipate that requirement will go away in New York. We don't know when. At this point, though, that is the law in New York. If you can only fall under this exemption so long as you receive the vaccine within the past 3 months. Again, do expect that to go away, but at this point, this is what you have to follow. Additionally, the guidance officially codified, for lack of a better term, that people who test positive for COVID-19 and recover within the past 3 months do not need to quarantine if they are exposed to someone, so long as they remain asymptomatic. And that 3-month period begins after the date of your symptom onset, or after the first positive test if the person remains asymptomatic. This guidance will matter for the travel advisory update. The travel advisory update, the big change was that there's no quarantine required for domestic travel beginning April 1. This was a very surprising announcement since it was announced on March 11th, and on March 10th, there was an update to the travel advisory. So what do you have to do between now and April 1? You have to follow this March 10th update to the travel advisory. What does it do? Fully vaccinated people who received the vaccine in the past 3 months do not need to quarantine upon returning from domestic travel. Same thing with asymptomatic people who have recovered from COVID within the past 3 months. They do not need to quarantine. That is a big change, but remember, we only have to deal with this for another 2 weeks. I can't wait to only deal with the travel advisory on this front for only another 2 weeks. But don't worry, the international travel advisory will remain. And there are differences now in how you have to quarantine. And this is very important. I know a lot of people have been booking trips to Aruba. Everybody's looking to get out, but they are going to have to quarantine. Your employees will have to quarantine upon return from international travel. This is consistent with the most recent CDC guidance. Air passengers coming to the US must either show that they received a test 3 days or that they have a documentation of COVID recovery within the past 3 months. Having your vaccine card doesn't make a difference here. It doesn't make a difference. Also, quarantine is required for everyone. There's no vaccine exception. There's no essential worker exception. Travelers have to quarantine for either 10 days or for 7 days with a test within 3 to 5 days upon return. That is a big change. And I screenshotted the New York guidance so I can make it very clear to everybody. The essential worker exception no longer exists for the travel advisory. That doesn't, we've talked a lot in this webinar about international travel, the travel between the US and Canada. But this is something different than just a commuter coming from Canada. We do have one more slide. It's just really brief. I've received a lot of questions on this. A quick thing, we've got a lot of questions about impeachment. Impeachment will start in the assembly. Simple majority needed to impeach. It's very similar to the federal in that level. If the governor is impeached, it is likely that the lieutenant governor would be the acting governor throughout the Senate trial. I say likely because this is becoming a constitutional question that will likely be very newsworthy in the next few weeks. The Senate trial, it's 62 senators. It excludes the Senate Majority Leader because she would be in the line of secession, plus the 7 judges of the Court of Appeals. You need the 2/3 vote for removal. And Pete, I'll kick it back to you.
All right, Katie. So a couple of things before we move on. First of all, the status of the current rules, even though they're being amended and revised, unaffected by impeachment if the rules are already in place. Is that a correct statement?
That's correct.
So everybody is, wondering what the impact of, the current issues will be on our current rules. The short answer to that is there isn't any immediate impact. It would depend on the outcome and how things proceed after impeachment or whatever else might happen.
Yeah, and remember that the lieutenant governor would become the acting governor. The lieutenant governor was handpicked by the governor to be the lieutenant governor, would likely continue down the same guidance paths, wouldn't be trying to come in and upend everything, would really try to make everything stable, as stable as can be.
Okay. Second thing I just wanted to briefly talk to you about is the legislation now signed by the governor, which allows paid time off for purposes of receiving a vaccine. It's up to 4 hours per shot, and
that is correct.
And it is paid time off.
That is also correct.
So we're getting a lot of questions. It's early days here, but we're getting a lot of questions about proof. I think we are comfortable with the idea that people would need to be able to demonstrate that they're actually getting the shot in order to demonstrate eligibility for this paid time off.
I agree with that.
And then we also would be in a situation where it's not 4 hours per shot, it's up to 4 hours per shot. And so what that's going to mean is for some people in some locations, they may not need much time at all. In fact, if they're getting their shot during off hours, they don't need any time.
Correct.
But if they need time during work, because that's when their appointment is, and the facility's nearby and travel is not a big deal, they may get a half an hour to 45 minutes off. On the other hand, in other situations, if they're driving or the facilities you have long lines, et cetera, you may get up to 4 hours.
Yes, I agree with that.
Okay, well, a lot of people have been asking questions about that, so we just wanted to make sure we hit on that. I would ordinarily have said we expect some guidance on that. As you indicated, guidance has slowed down quite a bit, so we may not see much.
I don't think we will.
Okay. Any other thoughts on that before we move on?
No, it's just been, we are keeping as on top of it as we can. We will continue to be looking for those guidance documents and reaching out to people within the governor's office, within the Department of Labor to receive clarification to issues that do arise. So if something does come up, please get in touch with us. We will do our best to get you the clarity that you need, especially given that the state is not offering the clarity that they were at one point. We will do our best to fill that gap for you.
Okay, great. Thank you. Let's move on to Aaron Torsello in our Buffalo office. Periodically, we've just given a little update on employment claims and the kind of the COVID connection, things to keep our eye on. So Aaron, take it away.
Thanks, Pete. Yes, so today I'm here to give us a little bit of an update about what we're seeing at the State Division of Human Rights and at the EEOC, particularly with regard to the COVID type claims. And this is pulling from not only my experience, but our department experience generally, and some of the discussions that we've been having internally about how to handle some of the charges that we're seeing come across our desks. So over the course of the past year, and I guess I should wish everyone a happy COVID 1-year anniversary. So we have seen a few types of charges more recently based on various COVID related issues. So one type of charge that we've seen is discrimination based on a COVID positive test. So a number of us are handling charges where an employee was terminated and has claimed that the reason for that termination was based on the fact that they tested positive for COVID at some point prior to the termination. Another probably more frequent type of claim that we've seen coming through both the Division of Human Rights and the EEOC is a failure to accommodate a COVID-related issue. So just to talk about that very quickly, every case is going to be different on these failure to accommodate COVID-related issue claims. And the reason for that is you may have individuals who tested positive for COVID and were requesting an accommodation based on that particular medical condition, not only during that first 2-week quarantine period, but you may have employees who are, I'll use the term long haulers, that are having continuing ongoing COVID-related symptoms that need some type of accommodation in the workplace. You may also have been faced with employees requesting an accommodation because they were in that category of higher risk, or you may be dealing with employees who are dealing with mental health related COVID issues. There's heightened anxiety or depression related to the status of us being in a COVID pandemic. So just as a quick reminder on these types of claims, because as I said, everyone is different in terms of the defense aspect, but they are all the same in terms of how we deal with them pre-charge, which is if you have an employee who has come to you with a COVID-related issue and needs some type of workplace accommodation, that immediately triggers our obligation to begin engaging in the interactive process, talking to that employee about what the facts and circumstances are, the need for an accommodation, why they need it, how long they need it, and inevitably whether or not we can provide the accommodation requested. One very obvious accommodation here is remote work, and that is also a charge, the basis of charges that we've seen, employers denying requests to work remotely, especially as we are beginning to return back to the workplace. I will use this as a reminder, the EEOC back last year issued some guidance on the ADA and reasonable accommodations, and whether or not remote work is now in and of itself a reasonable accommodation, given that we've all kind of moved, or not all of us, but many of us have moved to a remote work situation, if not full-time, at least part-time. And in that guidance, the EEOC indicated that just because we've provided remote work as an accommodation previously does not mean we have to continue providing that accommodation. Again, it's a case-by-case review. We have to determine what our operational needs are and whether or not continuing to provide a remote work situation would create an undue hardship. The length of the requested accommodation will come into play there, as well as what the person's job functions are and whether or not their presence in the office is an essential job duty. The next, and what I find somewhat interesting issue that we've seen, is on the FMLA front. And I'm not going to talk about the FFCRA or the emergency FMLA leave here, but I will indicate or let you know that some FMLA issues have been coming up in my own practice and in others as well. So this is just a reminder that if an individual has a serious health condition as a result of COVID, or have to care for someone who has a serious health condition that may be COVID, that FMLA leave may apply depending on whether or not they meet the rest of the eligibility criteria. However, we've also seen the FMLA come up in situations where employees may be requesting leave because they are concerned about coming back to the workplace. And the issue is, well, does FMLA apply there? And the US DOL has issued guidance which explicitly says that if an employee is not coming into the workplace because of a fear of COVID, that the FMLA should not apply in those situations. Now, that being said, there has been some resistance from at least one DOL investigator in particular pushing back on its own guidance. But that aside, the US DOL has issued guidance on this issue, but keep in mind that it's something that you might want to reach out to your attorney about and just make sure that you are checking off all those boxes as we're dealing with the issue of accommodations. And then very quickly, because I know that we still have a pretty full program, I wanted to touch very briefly on the procedural changes that we've seen in particular at the State Division of Human Rights level as a result of the COVID interruptions. So as we all know, COVID has impacted the courts as well as the administrative agencies that are really in charge of investigating and enforcing many of the employment laws that we're bound by. The Division of Human Rights in particular have experienced significant delays in processing charges from investigation through hearing. So in some of the cases that I have personally, I'm looking at a charge that was filed back in late 2018, early 2019, and I still don't have a pre-hearing settlement conference scheduled. Previously, those conferences were scheduled within, a 6 month to 8 month time frame, so we've seen significant delays. In response to that, the Division of Human Rights has launched what it is calling an early resolution pilot program to try and encourage parties to, while they are very purposeful in their avoidance of the term mediation in the launch of this early resolution pilot program, essentially what they've done is launch a mediation program to try and get cases resolved earlier on in the process. So if you are either currently dealing with a charge or a charge is filed in the near future, the attorney, hopefully a bond attorney who's helping you go get through that charge, will explain this process to you. But I did want to let you know that we are seeing some procedural changes just even as a result of the COVID interruptions. And with that, I will turn it back to Pete.
Thanks, Erin. Let me just try and answer a few of these questions that are coming up in our Q&A. It's the same question from a lot of different people. So I gather that people are very interested in this. There is no indication that this 4 hours of time per shot is retroactive. It's effective March 12th. So it appears to be March 12th forward. I think it would be rather remarkable and incredibly difficult to go back and do it retroactively. It is up to 4 hours. So, I mean, we've gotten questions already in the last couple of days, and in this particular webinar, should we just say 4 hours? I think our thought is no, you should say up to 4 hours and then afford the amount of time that's necessary. And then I think you are entitled to get proof, some sort of indication that the employee, in fact, is getting the shot. And I can imagine a variety of different things you might use there. So hopefully that answers a lot of the questions on the COVID leave, the COVID shot, the vaccine leave. Okay, so we're going to move on now to a different topic. We're going to come back at the end to the relief package, but we're going to talk about the New York Shield Act. It's a year later, and we've got a presentation here by Jessica Copeland, Teresa Rusnick. They're going to talk about the various aspects of complying with the SHIELD Act and what it means practically for us 1 year later.
Thank you, Pete. Nice to see everyone and change the topic a little bit. As the cybersecurity and data privacy attorney at Bond, one of several here, I am celebrating the 1 year anniversary of the effectiveness of one aspect of the SHIELD Act, and we'll talk about that. So for those who are not familiar, the New York SHIELD Act was signed into law July 25th, 2019, and there's a bilateral focus to this law. First feature of it relates purely to breach notification obligations in the event there is an incident that rises to the level of the definition of breach that would trigger notification. And for those that may have been impacted by incidents or breaches prior to October 23rd, 2019, it's important to know that obligations to notify were expanded by definition of what an event would be and the parties that or the organizations that this law applies to. We're not going to focus on your obligations for breach notification under SHIELD Act at this webinar. If anyone has questions, please feel free to follow up. More importantly, and as a healthy reminder, Teresa and I are here to make sure that on top of grappling with a year of a pandemic interruption, you've not lost sight of your obligations to comply with this rigorous cybersecurity mandate that issued from New York State. And it was effective March 21st, 2020. Next slide. So what does the cybersecurity mandate within the New York SHIELD Act actually require? There's safeguards that are itemized actually for administrative, technical, and physical safeguards that your organization must implement to protect New York resident electronic data. And it's important to recognize that this is not only for New York organizations, it affects any organization that holds or processes New York resident electronic data. Next slide. There is a small business carve out. I receive questions about this pretty regularly. So within the New York SHIELD Act, a small business has its definition of if there are fewer than 50 employees or less than 3 million in gross annual revenue for the last 3 years, or less than 5 million in year-end total assets, you would qualify as a small business, which does not mean that you are not required to implement reasonable cybersecurity standards within your organization and reasonable protections of New York resident electronic data. It really just means that your obligations are not as rigid as non-small business entities. In terms of what is reasonable, there's really no guidance other than considering the size of your organization and the type of sensitive or private information that you collect and process. Again, that invites questions. I'm happy to answer questions after if you want to contact me by email or phone. I can give a little bit more clarity on that, but as of now, all you need to know are what puts you into that category of a small business, and then we can go from there. Next slide. So administrative safeguards. It's important to note that while each of the itemized lists of safeguards doesn't necessarily call out that you need certain written plans for your organization, it's really embedded in what you need to do. So the first topic that people talk about is you need to have somebody that is going to, in your organization, coordinate the security program. Well, embedded in that is that you actually have a security program. You have to develop an information security plan for your organization. And it should be a written document that you can refer to as a resource, not only to make sure that you're complying with your own program, but in the event that there's an investigation by the New York State Attorney General to see if you're complying with the SHIELD Act, you'd be able to pull it out and say, yes, well, we've worked on this plan, it's robust, it's detailed, we know our risks and within the organization, we are working to mitigate them. So essential first item of business, if you do not have an information security program, written, a policy that you're adhering to, reach out, develop one. We work regularly with clients to do so. So make sure that's on your to-do list for compliance with the SHIELD Act. And then other safeguards that are necessary are training and managing employees to adhere to the security program, and also identifying any internal or external security risks that you might have. This is regularly performed by having a risk assessment done of your servers and network setup. And internal versus external is really, do you have the right protocols within your organization to protect private information? Meaning, have you set up certain permissions for a category of employees to access certain data that is not accessible by all employees? And then external security risks are, do you have the proper security patches in place with your cybersecurity solutions to make sure that you won't fall prey to phishing emails or other compromises? Next slide. Technical safeguards. It's important, like I said, to have a formal risk assessment. This is really the tool where you'll have an IT forensic company come in. You can have it done internally, but it is always best to have an outsider view to make sure that you have the most up-to-date security patches deployed, that you are monitoring for any potential intrusions. And one thing that would probably be a first order of business is to do sort of what's called a pen test to see where there are vulnerabilities within your IT solutions to make sure that they cannot be exploited. Next slide. And then physical safeguards refers to not only just where your network servers may be housed or whether you have cloud service providers, which is okay, but also how long are you retaining electronic data? And this is critical because it requires another policy to be written, which is your data retention and deletion policy. And I often get questions about, well, I need to retain this data because I'm obligated to if I'm ever audited. Certainly, if there's a legal reason for you to retain data, you certainly can. If it's sensitive data or private information, including social security number or bank account information, it should be encrypted and it should not be accessed by all employees. So keep that in mind. But certainly retaining data for compliance with other laws is an acceptable reason to not delete. The language is really what is reasonable for a business purpose. So it's not reasonable for you to retain customer data that you haven't sold a service or goods to in the last 10 years. That would be certainly unreasonable. Even 5 years would probably be considered unreasonable. A year, likely reasonable. Next slide. And there are penalties. So it's important to know that the SHIELD Act, while it doesn't create a private right of action for someone to come and sue you for lack of compliance with the SHIELD Act, it does enable the Attorney General to investigate and enforce the SHIELD Act, investigate noncompliance and then enforce against it. And already there are decisions that resulted from the Attorney General filing suit against organizations for data breaches. One to note is the Dunkin' Donuts data breach, which I don't know if anyone followed it or is familiar with it, but in 2019, Attorney General filed a lawsuit against Dunkin' Corp for a breach that they allege was not handled appropriately, that customers were not notified as soon as they should have been, and that certain cybersecurity solutions were not deployed appropriately. And the result of that was a consent order, so they reached a settlement where, in addition to refunding any customers who fraudulently lost money through their DD accounts, which is their Dunkin' Donuts website account for keeping money to pay on a card when you go to get your coffee and muffin, they can be refunded. But Dunkin' Corp was also fined $650,000 by the New York State Attorney General for failing to notify after they were aware of a breach. So interesting to know that if you do not notify according to your obligations under the SHIELD Act, you can be assessed fines that reflect the actual damages or actual losses of an individual that didn't receive notification, as well as if you were reckless in your failure to notify. Say you knew there was a breach that implicated Social Security numbers were accessed and unencrypted, and you decided it's unlikely that this is going to be an issue for those affected individuals. I don't want bad press. I'm not notifying. You could face fines up to $250,000. And then with respect to violations of not adhering to the cybersecurity mandates and those reasonable safeguards we just flew through, to the extent you are found to be in violation of any of those safeguards, you can be fined $5,000 per safeguard that's violated. I know I said a lot there. I need to turn it over to Teresa for what this means for employers, but thank you for paying attention. And if you have questions, I'm happy to answer them.
All right, thanks, Jessica, and hi, everyone. You're used to me talking about COVID and COVID employment implications, but I'm going to switch it up a little bit today because, as Jessica said, we are at about the 1-year anniversary of the SHIELD Act, which possibly became effective at the worst time for a non-COVID law to become effective, because I think people lost track of it. You know, I lost track of it in the pandemic and in the emergencies that were in front of us. But now, a year later, it's really come to my attention in a new way that employers can't afford to be negligent when it comes to their compliance with the SHIELD Act and with cybersecurity mandates in general. We're talking about the SHIELD Act today. I will say, if you have employees in other states, each state has its own version of cybersecurity laws that you need to make sure you're compliant with as well. I know California in particular has a very stringent law regarding cybersecurity. So just make sure you're compliant, not with just New York, but with the other states in which you have employees and likely do business as well. Every employer needs to be concerned about the SHIELD Act because every employer has information that's protected by the SHIELD Act. The definition of private information under the SHIELD Act is very broad. I listed some examples here. It's your name, it's a social security number, it's a driver's license number, it's a financial account, it's a username and email address that allows you to access an account, it's biometric information. All of those things are protected by the SHIELD Act and therefore need to be protected by employers. Now, how do you do that? Jessica mentioned the 3 types of safeguards. You need to make sure that you have policies to that effect, that you know what you're going to do if you have a breach and you know how you're protecting your employees and your customers' information. So to that end, you should develop policies on information security, breach notification, and matters related to those things. Should you make them part of the handbook? You can. I think generally I would advise that you just have them as almost a separate set of documents because there can be several of them and they can be extensive. They may not all properly belong in the handbook, but certainly you should have them and make them available to employees. Next slide, please. So policies and procedures can include an incident response plan, which Jessica talked about. If you have a breach, what are you going to do about the breach? In this remote world, how are we doing data security on mobile devices, on devices that people are using to work from home, especially? Jessica touched upon this, but you need to have a record retention policy. Every employer, every business should have one of these anyway for both employment records and other types of records. The SHIELD Act really drives home that it's important that you not retain those records beyond that reasonable amount of time in which you could be expected to need them. Different types of records have different retention periods. So any retention schedule would set up, how long you keep an I-9 versus how long you keep other personnel file documents. But when that time is up, and that time is set forth by federal or state law, per the SHIELD Act, those documents should no longer be in your possession if they contain that private information, which they very much likely do, given the broad definition of private information. Coordinate with other information privacy laws. I've listed 2 of them. I know there's more, HIPAA and FERPA. Make sure that your SHIELD Act compliance coordinates with those 2 laws and that your general data privacy and cybersecurity does as well. Next slide, please. So there are ways to do this where you collaborate between HR and IT. I do think even though cybersecurity and data breaches and all that might be more viewed in the IT realm, there's definitely a role for HR there as well, because it's going to involve employees. It's going to involve training employees on security practices and procedures, which generally would be a human resources function or a related human resources function. To the extent you're going to have policies and plans and they're going to be violated, HR would be involved in the investigation of those plans and policies and any discipline or termination of employees that might occur from that. Importantly, and I think it's good not to lose sight of this either, HR can help with vendor compliance. An employer has an obligation to make sure the vendors that they outsource private information to, be it employee information or customer information, are also compliant with the SHIELD Act and keep the confidential information from the employer confidential. And the way you usually do that is through a data confidentiality agreement. So, I think those are just some overarching highlights for the New York SHIELD Act and data security in general. I do a lot of handbooks, and I often advise employers on other aspects of policy compliance. I think cybersecurity goes right along with that. I think it's important that all employers be aware of it. They be aware of the penalties that could occur if you're not compliant with this. Jessica mentioned the Attorney General. There can also be broad-based negligent lawsuits brought. There's a class action right now in Massachusetts that's involved with the SHIELD Act and negligence for cybersecurity. Certainly that's not a situation we would want any of you to find yourselves in. And if it were to be a situation that you find yourselves in, we want you to have the best defenses possible in place if that should happen. So that's our 10 minutes on cybersecurity. Pete, we'll turn it back to you.
Thank you, Teresa. Thank you, Jessica. Appreciate that update. Some good things to keep in mind. Okay, we're going to turn now to Tom Eron. And we had talked a little bit about this last week, that some of the pension relief provisions in the federal legislation. Tom's going to dive into that a little bit deeper and focus on what those look like and what they may mean for you. Tom?
Thanks, Pete. Good afternoon, everyone. Very much appreciate your joining us this afternoon. As Pete mentioned, we're in the process of unpacking that massive relief legislation that was passed last week, and we'll have a series of programs talking about the various provisions. I'm focusing on the multi-employer pension plan relief, and in particular, the perspective from the participating employer. So this is not a comprehensive overview of that statutory, those statutory changes as it relates to plan operation and administration, but really focused on what does it mean for the participating employer. And those who are participating employers have faced a dilemma in recent years between making the decision as to whether they move to withdraw from the plan, usually through collective bargaining, and face the potential of withdrawal liability, which can be significant, or remain in the plan. And a number of these plans are struggling and underfunded. And so the risk exists that the plan could become insolvent in the near future. And also that there are significant contributions being made by these participating employers in the underfunded plans that largely go to funding prior benefit accruals and are not supporting current employee retirement accruals. And that's a difficult position to be in. There's been a great deal of discussion and proposals and lobbying in Washington. And finally, we have the enactment last week of a provision that was colloquially known as the Butch-Lewis Act, but essentially it is a government bailout of the multi-employer plans that are in the worst financial condition. So we're talking about plans that are already insolvent, plans that are anticipated to become insolvent within the next 5 years, plans that had a potential financial impact of $1 billion or more. And included in here are the plans that took corrective action under the Reform Act of 2014. So those plans implemented a reduction in already accrued benefits as a way to stay afloat. And this legislation allows them to reverse those reductions, actually called suspensions, but limitations on prior accrued benefits, reverse those and take this federal bailout money. And the structure is very simple. It is a lump sum grant. It's not a loan. There's no repayment obligation. It's a lump sum grant to the plan. And it's intended to meet the obligation of the plan to pay the accrued benefits, the benefits that are already obligated, that would be paid out over the next 30 years. And the number that's been thrown around is that this is a $86 billion infusion of cash into these 250 troubled plans that cover 1 million plus employees and retirees. So what does it mean for the participating employers? Well, really, I have 5 takeaways for you. First of all, of course, in the short term, it eases the concerns, right? That clearly, if the plan is going to take advantage of this grant process, and it is on an expedited timeline, the PBGC is required to put out regulations within 120 days. And then once applications are received, the PBGC is required to respond to those applications within 120 days. So it's conceivable that plans would see this money this year, more likely next year, but a quick cash infusion. So it takes the pressure off. If you're in the plan now, the risk of insolvency in the short term, or if you're in an insolvent plan, that risk goes away. But long term, the 5 takeaways. The first 3 are all related, and they go to, will this work, right? First of all, we're talking about an infusion of cash into the plan, which means the liabilities remain in the plan. The risk is still there if that cash and other assets aren't sufficient. While there is a segregation called for in the legislation, there is not an obligation in the legislation to create a separate or subsidiary plan. It appears to be part of the same whole plan that exists today. The second concern that I see is that there's not a clear alignment between the investment of these funds and the actual payout of accrued benefits. Those accrued benefits are going to be measured on a present value basis based on the plan's assumed rate of return. The funds, according to the legislation, must be invested in investment grade bonds. And to my mind, there's no guarantee that the return from those investments will necessarily be sufficient to pay off all the liabilities as estimated. And then probably the biggest piece of this is that there's no structural change here. We have the same system that got us to the present point and the significant underfunding that exists. And Congress did not take up the many different options that were laid before it on how to restructure the multi-employer plan system to prevent this underfunding from developing in the future. So, if you're looking at this risk long-term as a participating employer, it depends on your confidence in the stakeholders, the trustees, the unions that you deal with, the other employers in the plan to make the right decisions on the use of the monies so that they go toward paying the accrued benefits and don't get misdirected in some way, shape, or form through the administration of the plan or through the collective bargaining process, et cetera. So to me, there remains risks with continued participation. The next takeaway has to do with the rehabilitation plan implications here. All these plans are in critical and declining status, so they have a rehabilitation plan in place, which calls for limits on current accrual of benefits and often significant increases in employer contributions. Under the legislation, the plans remain in critical status, which to me means they continue to have a rehabilitation plan. But most of that money that we've been paying, we the employers have been paying under a rehabilitation plan, has gone to pay past underfundedness. So looking ahead, there's a reasonable expectation that those rehabilitation plans will be revised now that the plan has the federal funds in place. And so can it mean a loosening of the restrictions on current accruals so that your current employees see the benefit of the dollars that you're putting into the plan? And can it mean a reduction in the amount of assessments that come with those rehabilitation plans? And that will certainly be a balancing that faces the employer and union trustees under the oversight of the PBGC. And finally, there's the issue of future withdrawal liability. When this bill passed the House, it had a provision that that required, if an employer withdrew within the 15 years after the plan received the federal funding, then that federal funds would not be included in the calculation of withdrawal liability. So the employer would have a disincentive to withdraw because its liability would be the same as if the plan never received those federal funds. Because of the peculiarities of how this legislation was passed, that provision was removed in the Senate review and approval process. So as it stands today, there is no limitation on withdrawal liability as we move forward in these plans that accept this federal funding. And obviously, it's going to create a tremendous incentive for employers to withdraw shortly after in the years after the plan receives the federal funding, because the plan will be in its best financial position at that point. I don't expect that to go unnoticed by the PBGC. I would expect the PBGC to develop regulations that in some way, shape, or form take the replace that provision and take away the incentive or create a disincentive for employers to withdraw upon the shortly after the fund receives this federal financial assistance. So we'll have to see what comes in those regulations. And I think this withdrawal liability issue is the principal one for employers to consider as we move forward. That's a quick summary, Pete. I turn it back over to you. Thank you.
Tom, it'll be interesting in light of that legislative history, how far the PBGC could go with those rules. So
yeah, that's a very good point. Yes.
Okay, well, that's for those of you who are faced with those issues, those will be very important provisions to keep our eye on. Okay, thanks everyone for being with us. We really appreciate it. Sorry we ran over a little bit today. We'll be back here next Tuesday. We look forward to seeing you then. In the meantime, please stay safe.